Back with my esteemed colleagues to talk now about compelling reasons and why not to file a termination of parental rights. We're going to serve as a panel again. And the first question I'd like to look at and consider is, what is the primary consideration in determining whether or not compelling reasons exist to not file a termination of parental rights petition? And I would like Jenny to start with you.
Thank you, Ashley. The primary consideration in determining whether compelling reasons exist is what's in the best interest of the child. There's numerous factors that need to be considered, such as where the child's placed, how long the child has lived there. But overall, it's the best interest of the child. It's not the best interest of the family or what the family would like or a particular parent. But the decision needs to be made with focus and emphasis on the best interests of the child. The statute also provides some guidance. I believe we have that in some of the handouts of various factors to be considered in making that best interest determination.
And I'd like to open it up, Buffy and Ross, for any examples that you may have from practice of how parent actions may be considered over the best interest standard that Jenny just raised in determining whether compelling reasons exist. Buffy, if I could throw that to you.
Sure. I can't tell you the number of hearings that I've been in where the statement at the end of the hearing, or the statement primarily from the parent's attorney, and if I were a parent's attorney, I would make it too, to say my client is making progress and so they need more time. And then you'll see that translated in the court order to say compelling reasons exist to not file a termination of parental rights petition because the parents are making progress and therefore it's in the best interest of the child. But nothing that ties how that's in the best interest of the child. So I think one of the things that is missing in that analysis is the impact on the child. I think you could certainly make that conclusion if you added and had additional facts, the age of the child, the relationship between the child and the parent, how the parent's progress is going to result in the ability to reunify within a very reasonable period of time from that point forward. So you have to have that additional analysis. So sometimes it is there, but many times it's not, because if it is just based on the parents need more time, that doesn't translate into the best interest of the child.
And the reality is, we all know you have to have a finding of fact, a conclusion of law, and if that analysis is done but is not contained in the court order, as you just mentioned, you need both of those prongs, right? Because if it's not in the court order, if it were to be appealed, there's questionably an argument around it wasn't a compelling reason in the best interest of the child. Ross, let me ask you, do you have any other thoughts and experience about other examples of when maybe something's being considered over the best interest of the child?
You know, I think Buffy really hit the nail on the head with her example, and I think we see that a lot, a parent realizing that, like, this is it, and so they, maybe their attorney is letting them know, like, hey, at this next hearing, the judge is probably going to order that we go forward with termination of parental rights, and all of a sudden there's action on the case plan. Sometimes it may be an underlying issue that just actually takes longer to deal with, as like substance abuse or something like that, where like it actually takes longer than the feds have thought in their timelines for somebody to get a handle over that and to move forward. So, I think you definitely see kind of that request for more time, or hey, the parent has started, has turned a corner. They're really doing good now. We should have more time, and if you can tie that to the best interest of the child, I think that makes sense. But I think you have a situation where a lot of judges are hesitant to pull the trigger on that termination of parental rights, and that compelling reasons kind of gives them, a crutch or an escape hatch before making that decision. And it's there for an important reason. It's just, it has to be tied to the best interest of the child, and not just because we want to see if maybe some more time can get this case turned around. And so I think, like I said, Buffy hit the nail on the head in terms of parent needs more time. There's compelling reasons not to file. So, we're not going to go forward. It's just not quite how it's supposed to be working.
I want to jump in on the example that Ross gave, because I think that it was a really good example, and it's probably the one that we see more than any other scenario of, we know that dealing with substance abuse does take a long time. But again, if you are critically thinking and critically looking at the facts that are presented as to whether or not that's in the best interest of the child, then you have to look at more than, well, substance abuse takes a long time. I mean, so that's what we end up hearing then. Well, it takes a long time to deal with substance abuse, and relapse is expected. But when you really dig down and look at the facts of those situations, you have to look at where we are in the case. When did they start substance abuse treatment? How many times have they been through that process? What is the likelihood of a successful completion of that process and the ability to reunify? Are there other factors? Will they still have to obtain housing, employment after they've made more progress on the substance abuse side? So you have to ask all those additional questions. And one of the things that we can't then do is just fall into, okay, well, substance abuse treatment takes a long time. So I think all of this comes back to that critical thinking and really saying what facts make it best for the child in order to give them more time for this particular issue.
All right, so we know it has to be, it's in the child's best interest. But Ross, I'm going to ask you a question that, again, many jurisdictions face this issue. So my question for you is it necessary to identify an adoptive home before proceeding with TPR?
No, it's not required. And I think, again, in each of these steps throughout all of the trainings we're doing, if you center yourself in the best interest of the child, you're going to land on the right answer. And so no, in fact, many times the what was called a legal risk for a youth whose parental rights have not been terminated may actually make it more difficult for that youth to become adopted. So I think some courts go to that question like, well, it can't be in the best interest if you don't have an adoptive placement lined up. And that is the wrong direction. It can be helpful to know that there is an adoptive placement set up, but it's not a controlling issue. So it's inappropriate for courts to be saying, well, it's not time because you don't have an adoptive placement set up. It's just not a requirement anywhere in statute, regulation, or even best practice.
And Jenny, I know that Ross just shared, for example, it may be more difficult for an older child to have found a home if rights aren't terminated. But can you share any other benefits of terminating parental rights when an adoptive resource has not, in fact, been located?
Sure. There's lots of different pools and recruitment efforts that an agency can make once a child is legally free. Many people want to adopt children, but they don't want to deal with the foster care process and waiting to determine whether or not a child is going to become legally free. They don't want to invest the emotional time and effort to find out, oh, this child's going to be reunified. So there's a whole pool of resources out there where the families will only consider children that have been declared to be legally free. And also to tie in on what Ross was saying is there's actually Nevada case law on point to this, that an the agency does not have to prove an adoptive resource before the court can grant a termination of parental rights. So taking that back to a review hearing when discussions are being had about what the permanency plan should be, you're still 3-6 months out before you're at a termination proceeding from that 12-month review hearing, which still does give parents time. However, they can be recruiting for adoptive resources during that time frame. And that should be something that the court's considering, not only in determining whether rights should be terminated at a termination hearing, but also what they are considering in determining if the plan should be changed to adoption. and if it's in the best interest of the child to do so.
Thank you, Jenny. I want to turn our attention now. You all have heard about the restoration statute. So what is the benefit of that statute, and how can it be used down the road to restore parental rights? And if I could start with you, Buffy.
I'll first say that it's a statute that I have not seen used. And, you know, I think the benefit of having that statute is for what we've been talking about, that there are many barriers to finding an adoptive placement when there's still parental rights intact for the reasons that have been discussed. And so if we were to actually use the restoration statute and see people be able to use that, the benefit of that is that we can have appropriate permanency planning for children. It is definitely the exception that we're not able to find an adoptive placement for a child once rights have been terminated. But in those few cases, using that restoration statute, you may not end up being able to have the child physically reunified with the parent, but legally reunified with their family of origin. Because that is one thing that we don't want to see, is a child who doesn't have a legal relationship to any family. That's what we want to avoid. And that was one of the reasons for that statute.
And I know the jurisdiction where I am, which we know is in a different state, it is a rarity that it's used. But I would suggest, just like you said, Buffy, in the very right circumstances, it should be considered. And I'm thinking of an example of an older child whose vulnerabilities have changed with age, where a parent's protective capacities have also changed because of their circumstances. And the child says, and everybody knows, I'm going back to my family, or I want the benefit of having my family. Would you agree, Ross and Jenny, I'd like to throw it to each of you, if that might be a specific set of facts in which it could be considered? And is it a tool in the toolbox that you feel like has been yet unexplored? Jenny.
Yes, I actually have seen the restoration statutes used. I've personally filed a couple of them over the years since enactment of that statute, and that was the exact circumstance that occurred, where we had a child whose parental rights were terminated at a younger age, like 10, 11, 12 years old, and we were unable to identify an adoptive resource. And as that child continued to grow, we recontacted the biological parents. We reassessed them, determined, have your life circumstances changed? It's been a few years, what's going on with you? Is it safe for this child to be returned to your care? And we have used that statute to restore parental rights. And sometimes it's an older child asking for it. The statute does permit for a child or a child's attorney to file to have parental rights restored, or the agency can do it. So I do think that it is used. I would agree with Buffy that it's not used all the time, but we have used it to some extent.
All right, Ross, anything to add from the agency perspective, either on the restoration of parental rights, TPR, or compelling reasons?
I think you hit the example where that restoration of rights is perfectly used, and I think I have not seen it used, just like Buffy, out in our rural jurisdictions, although it may, and I may not be aware of it. I think, a lot of courts, they've read the case law that says the termination of parental rights is the civil death penalty, and so they really get hung up on, like, if I do this, it can never be undone. Well, that's not true, right? We have a whole process in statute that allows it to be undone if, again, that continues, that if the situation changes and it's in the best interest of the child. So I think for those watching the training to know that tool is in the toolbox, and that might make you more comfortable with going forward with a TPR to see if there's a way to have permanency through adoption for a child, knowing that if that does not work out and the situation changes, there's a process in law to reverse that termination.
And I want to jump in on that, Ashley, where I foresee that statute being used more, or at least being considered more, because of our progress in making sure that every child is represented by an attorney. For years and years, we knew that children should be represented by attorneys, but we had varying degrees of success with that depending on which jurisdiction you're in. More recent statutory changes and funding changes have changed that in a positive way, to where in most jurisdictions, I can't speak for every single rural jurisdiction, but I know in our jurisdiction, every child is represented by an attorney. So that's a huge change that I think is going to impact the use of that statute, because now that child will have a stronger voice and an ability to implement that statute, as Jenny pointed out.
Great points all, and I appreciate how you can all dovetail the different pieces of the law, which as practitioners is something that's so important to do. Appreciate all three of you serving on this panel as we talked through the TPR compelling recent issues.